I had a video. I had audio problems this morning and I had to restart my computer. And I'm glad that I came in early. I was here about 10 after 8 in the office. Oh, it's snowing here, which is exciting. But I don't know if that had anything to do with my computer, but it wasn't working right.
Yeah, I like to get on these early just to make sure everything's ready to go.
Okay, I just got the Zoom notice that we are being live streamed, so we are on YouTube. Thank you, Anna. Appreciate your help on that. All right, let's see what my handheld computer says. It's 8:53, so we've got 7 minutes before we're scheduled to go. While we're here, I won't waste any time. Mr. Bogotko, how long do you think you would have in cross-examining Mr. Pollock?
Mr. Hearing Examiner, I do not have any cross-examination for Mr. Pollock.
Wow, amazing. Mr.
Do you want me to?
No.
Okay.
Well, I have some questions for him. You know, that's a good question. I like you guys to clear up any ambiguities that I recognize before I have to do it. So the answer is yes, in a way.
Well, unfortunately, my cross, I think, would probably fall into the definition of friendly cross, since we are aligned on the balance of issues.
Okay, got it, loud and clear. Well, I don't cross at all. I just examine when I recognize ambiguities or if I want to make the record more clear, which is, a different kind of animal. And often I have a list of questions after I review testimony, but the counsel for the various parties steal my thunder, if you will. And by the time you get to me, there's no more questions left, which is great. That's the way it should be. Anyhow, Mr. McMillan, good morning. Can we check your video and audio?
Yes, Your Honor. Good morning.
Good morning. We are live streaming on YouTube, I'll remind you. Have you spoken to Mr. Pollock this morning?
I have, yes. He plans to be here and is feeling up to testify.
Wonderful. I understand that you spoke with opposing counsel, but they would not waive cross-examinations. Is my understanding correct?
That's correct, Your Honor. Ms. Kane and I talked, and we came out a couple of possible solutions, and just something that worked really well for us. So here we are.
Mr. McMillan, you're breaking up on my end.
On my end too, really bad. So you might need to delete your video just to have good audio, Mr. McMillan. We'll see.
Let me try reconnecting.
Okay, thank you, sir. Good morning, Ms. Drake. How are you?
Good morning. I'm good, thank you. And you?
Good. Glad to hear you. I just want to check the audio and make sure we were all online.
Sure.
Mr. McMillan was here. He just checked out and he'll be back. Hi, Ms. Kane. How are you today?
Good. Good morning.
Good morning. Is that a corporate logo behind you?
It is. Is that permissible? Just want to make sure.
Well, sometimes one of our staff appears as a cat. So
I can change. I think our other option is like a solar array. If that would be preferred, I can make that change, or a wind turbine.
Either or is no. It's all fine. It's all fine with me. I just asked because I was just staring at Mr. Pollock's corporate logo within the caption of a pleading, and then I see yours behind you. I actually understand. I studied marketing in graduate school, so I understand the whole concept of corporate logos.
Yeah, there are our approved backgrounds, our library of approved backgrounds, as they say.
Excellent. Mr. Bogotko, you're back. Let's see if your audio works in your video.
All right. How's that? Can you hear me?
Perfect.
Very
nice
good. Thank
furniture,
you.
Mr. Bogotko.
I'm sorry, what?
I was just teasing you. Nice furniture.
Oh, yeah, I'm working from home today because we got a lot of snow out here, and I'm thinking it's just safer to stay put.
Is that an Ovation guitar I see there?
That is It's a Takamine solid body electric guitar.
Well, it's hard to just tell by that, the little bit I can see, but I got it. I understand. Anyhow, we are waiting for Mr. McMillan's witness. Is that correct, Mr. McMillan?
Yes, Your Honor. I'll shoot him a text to tell him that that it looks like we're ready for him.
Thank you.
Can y'all hear me better now?
Yes, sir. Much better. We are live streaming. We'll get this started as early as possible, as soon as the witness gets here, with everyone's permission. It's 8:58, and I got an email that cross-examination from at least one party expected to last only a half an hour. Mr. Bragato said he doesn't have any cross-examination. Mr. Rushoff, do you anticipate cross-examination?
No, I don't have any.
Excellent. Ms. Kane, you said a half an hour, right? Okay.
Yes, and that's on the outer edge, I would have to say, but we'll see.
I
Okay.
don't have any cross-exam either for this witness.
Well, this could be wonderful. Mr. Lee, that's all good news. Hi, Mr. Pollock. It's good to put a face to a name. How are you today? That's exactly why I ask you, because can you turn on your audio, please?
There's my audio. Can you hear me
wonderful.
okay?
Yes, sir. Good morning. We're not on the record yet. It's nice and snowy here in Santa Fe. How is it where you are?
Cloudy and warm.
Good for you. You're in Northwest St. Louis suburbs, right?
West counties. Yeah, West St. Louis County. Yes.
Okay, wonderful. We're not going to do too much small talk. We're going to get started sooner rather than later, which is in 1 minute, according to my clock. We don't start early though, because we are noted to start at 9 a.m. and we are on YouTube, and the public has a right to be here. And I don't want the public to miss anything if anyone is tuned in to hear this. It's like the bus, the bus can come late, but the bus can't leave the stop early. I don't know if you guys lived in a city and rode buses, but that's the way buses work.
Yes.
Ideally, they work that way.
Ideally, that way. Ideals, that's a great word. An ideal. All right, let's see here. I'm ready to go on the record. Are you ready, Mr. Lee?
Yes, sir.
Good morning, everyone. My name is Robert Lennon. I am a hearing examiner for the New Mexico Public Regulation Commission. This is the continuation of case number 22-00177 UT. This case began as scheduled on October 26, 2022, as scheduled and as noted and as notified to the public. We were scheduled for 3 days. We were fortunate to be able to complete most of the testimony before the end of the day on the 26th. There was one gentleman who could not appear, Mr. Pollock, because he was sick. He is a witness for Occidental Permian Limited. And Mr. Pollock is available today. So we're continuing the case to allow the submission or the move into into evidence of his direct testimony, and then allow cross-examination as required. I'm going to begin with a statement of the last line of page 274 of the transcript. And I'm going to quote myself where I state, we will be reconvening unless something else happens such that we don't have to at 9 a.m. on Friday the 4th. And I was referring.
Your Honor?
Yeah, on October, don't interrupt me, please. I was referring on October 26th to November 4th. I apologize. Go ahead, Ms. Kane.
Oh, no, my apologies. I received a text from somebody who said that they cannot hear the audio on the YouTube feed. I don't know. I'm not on there, so I'm not able to check myself, but I just wanted to make you aware.
Well, I'm not on there either. What I will do, I don't know about that particular person. What I will do, Mr. Lee, can we go on the record, off the record for a moment?
Yes, sir.
Thank you. Everyone, we're off the record. And that's more or less just to save expenses, and it's not necessary to be on the record for this type of matter. I'm going to contact Anna and tell her to, excuse me, straighten that out, because that's what she does.
And it may just be that one user. My apologies. I just wanted to let you know because that's the information I received.
Yeah, that's what I was thinking too. One user could have issues.
Oh, I received a message that the audio is now working. So
Well,
we should be good.
I hope this is a very important person that you receive that message.
Well, these were two different people, if it's any consolation.
It is somewhat. Are these employees of SPS?
Yes.
Okay, thank you very much. All right, Mr. Lee, may we go back on the record?
At your leisure, Your Honor.
So back on the record, we just had a purely procedural off the record conversation concerning the audio on the YouTube feed, nothing concerning the merits of the case. Before we went off the record, I had just dictated into the record for continuity's sake, frankly, lines 23, 24, and 25 of page 274 of the record as it exists. And that ties in that hearing with this hearing. It's the same hearing. This is a continuation of that hearing. Not waste any more time. Mr. Lee, would you please swear in Mr. Pollack? And Mr. Pollack, Mr. Lee will swear you in. Thank you.
Would you please raise your right hand? You solemnly swear the testimony you're about to give in the matter and upending should be the truth, the whole truth, and nothing but the truth?
Yes.
Thank
Mr.
you.
McMillan. Thank you, Mr. Lee and Mr. Pollack. Mr. McMillan, your witness.
Good morning, Mr. Pollack. Could you introduce yourself?
Jeffrey Pollack.
And are you the same Jeffrey Pollack who submitted direct testimony in this case?
Yes.
So you should have in front of you a copy of OPL Exhibit number 1, which is your direct testimony, and OPL Exhibit 1A, which is the work papers to your direct testimony. Do those appear to be true and correct copies of those documents?
Yes.
And if you were asked the same questions today, would you provide the same answers?
Would.
Your Honor, OPL offers Exhibits 1 and 1A.
Sorry, but I didn't hear that last answer. What was it? You were asking if this would be the same testimony, and it was garbled on this end.
Sorry. Yes.
Yes, thank you. And you moved to admit, is that correct, Mr. McMillan? Thank you. Let's see if there's any objection. Ms. Kane, no objection.
No objection.
Thank you, Ms. Drake. Ms. Drake,
No objection.
Mr. Rushoff,
No objection.
certainly not least, but last, Mr. Regato.
Mr. Hearing Examiner, no objection. Thank you.
Thank you. As you guys all know, I try to make this as clear as possible for the record. There being no objection, direct testimony of Jeffrey Pollack dated September 26, 2022 with attachments, and I have 2 appendixes as well, is admitted into the record. Are we ready to proceed to cross-examination? Thank you.
Yes, Your Honor.
Before we go into cross-examination, I had some housekeeping I wanted to take care of. I wanted to have Mr. Pollack explain under oath why he was not present last week, October 26th, when this matter was scheduled. Mr. Pollack, could you please, for the record, answer that question?
Yes, Your Honor. So while I was away, I broke out in a shingles rash and I was in serious, severe pain and literally could not think or do anything for a while. So I appreciate the letting me heal for the next the week.
Thank you, Mr. Pollack. Okay, Ms. Kane, he's your witness.
Thank you. Good morning, Mr. Pollack.
Good morning.
Thank you for being here, and I hope you're feeling better.
Just be sure you get your shot. Shingles is a terrible thing to have to live with.
I think that's a good PSA on your part. I just want to ask you a few questions about your testimony in this case. First, in your testimony, you speak to the carbon emissions cost benefit analysis in the PRC's rule, correct? And is that a yes?
Yes.
Okay. And is it your position that carbon emissions reduction is the only quantifiable or recognizable benefit related to renewable energy generation?
Well, it's the methodology that's specified in the rule, but there could be other mechanisms that you could use to try to quantify the benefits and costs of renewable resources.
So is your answer that no, there may be other additional benefits other than carbon emissions reduction?
Yes, there could be other benefits. My answer was that the rule only measures the carbon reduction emission benefits.
So would you agree that there could be perhaps economic benefits related to the acquisition of renewable energy generation?
I think you'd have to be a little more specific about what economic benefits there are, and there are also economic costs. So you'd have to look at both.
So could there be job creation benefits associated with the construction of renewable energy generation?
There could be, yes.
Okay. Would you agree that there may be energy self-sufficiency benefits that could attach to the acquisition of renewable energy generation?
What do you mean by energy self-sufficiency?
Usually the witness doesn't ask questions, but I understand you need some clarity in order to answer the question.
I do.
So
I
I'd ask
definitely
you
do.
not to ask questions. Thank you.
Okay.
You could indicate that I don't understand your question.
So what is your conception, Mr. Pollack, of energy self-sufficiency?
I don't have one.
You don't have any conception of what energy self-sufficiency might mean?
I don't understand the term.
Okay. How about energy reliability or electric reliability benefits? Could there be reliability benefits that attach to the acquisition of renewable energy generation?
There certainly are reliability implications associated with that, not necessarily benefits. There could be reliability costs associated with renewable resources. So you have to look at both things.
Okay, so but you would agree that there could be benefits. Is that a yes or no answer?
There are some benefits, yes. There are benefits and costs.
Do you agree that in the Renewable Energy Act that the legislature identified benefits attaching to renewable energy generation other than carbon emission reductions?
I don't recall exactly the language in the legislation. If you could point me to a specific part, I could refresh my memory.
Did you review it? Let me ask you this. Did you review the Renewable Energy Act prior to appearing today?
I've reviewed it in the past. I briefly reviewed it this morning.
Okay. Your Honor, I'm not sure if there are exhibits available. The large customer group exhibit 2, I'd like to refer to, but I'm not sure for purposes of showing the witness what would be the best way to go about.
Well, I can change so that you can share your screen. If you have it on another screen, I can enable that, I believe. Would you like to do that?
If we could.
Okay, let me see if I can arrange that.
I do have a share screen feature here that I might be able to utilize.
We'll try it, see if it works. And if not, I'll have to change something on
Oh, it says it's disabled. My apologies.
No problem. Thank you. And while I do this, Mr. Lee, you can continue. I have a comment. I want to remind everyone, including anybody that might be watching, what we are doing now is cross-examination. And cross-examination is different than direct examination, obviously. During cross-examination, pardon me, I'm trying to do two things at once.
And Your Honor, I can move on to if this is not critical.
Well, let's see if it is critical or not. If you refer to a part and he's familiar with it, we won't have a problem. But what I was saying while I was trying to do two things at once is that, the very nature of cross-examination is adversarial. And I'd ask Mr. Pollock to keep that in mind. It's not him testifying, it's him being cross-examined. Okay, please proceed, Ms. King.
Okay, let's move on. So in your testimony, you indicated your position that you believe that the regulatory compact, as it were, provides sufficient incentives for utilities to acquire or invest in renewable energy. Is that a correct statement of your position?
Yes.
So, but you would agree that the legislature provided provisions for incentives in the Renewable Energy Act related to the acquisition of renewable energy, correct?
That's my understanding, that the legislature said that upon a motion of the utility or the commission, that you could develop a mechanism to provide an incentive for exceeding the existing RPS standards.
And let me ask you, you also say in your testimony that it's your position that the commission should demand, I believe you put it, a much higher standard of proof to obtain an incentive other than showing an exceedance of the renewable portfolio standard. Is that correct?
Sorry, do you have a reference to my testimony?
Sure. If you can look on page, let's see here, on page 5, I believe, of your testimony, at the top, in line 5.
Thank you.
And I'm happy to read that to you. And maybe I will
I
just,
have it in front of me. Thank you.
sure. So for purposes of the record, I'd just like to read on page 5, line 5, you indicate that the commission should demand that the utility meet a much higher standard of proof other than simply exceeding a specified RPS requirement as a prerequisite for receiving an additional reward. Is that a correct reading of your testimony? And when you speak of reward, are you speaking to the financial incentive?
I can't hear you, Mr. Pollock.
I'm sorry, Your Honor. Yes.
Thank you.
I'll turn up my volume a little bit.
Now, can you, would you agree that the Renewable Energy Act provides for the ability to seek a financial incentive for exceeding the renewable portfolio standard?
Yes.
Okay. And so what is your basis? I'm just curious as to what your basis is for your statement that there needs to be a much higher standard of proof to obtain the financial incentive.
So the statement basically says you need to, continue reading the testimony, the utility should provide compelling evidence that the cost to achieve or exceed the standard have resulted in clear benefits to the customers.
I see achieve a particular goal language, which is different than you just recited, Mr. Pollock. Is that correct?
I'm sorry, could you repeat that, Your Honor?
Yeah, I believe you misquoted yourself. I'm going to read from line 7. The higher standard must include compelling evidence demonstrating that the cost to achieve a particular goal have resulted in a clear benefit to the utility's customers. That's not what you just read to me. Maybe you're looking at some prior version of your testimony.
That's accurate, Your Honor. I was kind of paraphrasing that and saying, in this case, particular goal means exceeding the standard.
Okay, when we quote, please read, don't paraphrase. Thank you.
Sure.
So that statement that the hearing examiner just read, is that found anywhere in the statute that you're aware of?
And you're being specific to the RPS standard that we're talking about.
And excuse me, when I say the statute, I mean anywhere in the Renewable Energy Act.
Renewable Energy Act. I don't know that statement is exactly from. It's certainly not a quote from the Renewable Energy Act. However, it's part of a kind of an overarching standard that the commission would have in its authority to rate making, to setting rates for utilities. That it's not enough just to exceed a standard. You should also do so in a way that's cost effective. And I think that's just an overarching principle that the commission uses in its, in setting rates for setting electric rates.
So can you point to a particular statutory provision that reflects that in the Renewable Energy Act?
Not specifically in the Renewable Energy Act, other than the fact that the REA does specify a reasonable cost threshold, which suggests that the legislature had in mind that the utility shouldn't go out and procure renewable energy at any cost. It should be at a reasonable cost, and it should also, provide a benefit to the customers.
So is it your position that the reasonable cost threshold in the Renewable Energy Act is a essentially kind of valid marker for determining whether or not a utility is acquiring generation at a reasonable cost?
It's a way of saying we don't want the utilities to acquire renewable energy at any cost, meaning that the commission or the legislature intended that we want the utilities to acquire renewable energy, but we want them to do so in an efficient manner.
So if a utility could show that its request for financial incentive does not result in exceedance of the renewable cost threshold, would you think that would be a reasonable marker for analyzing a financial incentive request?
No, I think the financial incentive request has to meet two tests in particular. One is that the action that associated with the financial incentive must have been taken after the commission has promulgated a rule saying here's what the standard is and here's how you measure whether you're entitled to an incentive. So it's forward looking. The second is that the incentive must only be justified if the utility can, as my testimony states, provides compelling evidence that the cost to exceed the standard, in this case, that's the particular goal, have resulted in a clear benefit to the utility's customers.
Okay, but I don't believe you answered my question. So is the renewable cost threshold, if a utility could show that their financial incentive request does not result in exceedance of the renewable cost threshold, do you believe that that would be a reasonable marker for judging a financial incentive request, the reasonable cost of a financial incentive request?
No, even if the utility acquired a resource at the reasonable cost threshold, or even below the reasonable cost threshold, if the additional cost doesn't exceed or isn't exceeded by the corresponding benefit, then the utility would not be entitled to a financial incentive. So just the acquiring the resource at the reasonable cost threshold is not in itself indicative of whether the utility is entitled to a financial incentive. And
is your position that you just stated reflected anywhere in a particular statutory provision in the Renewable Energy Act that you're aware of?
No, I don't know that it's the specific statement is in the Renewable Energy Act, but it's based on my understanding of the overall regulatory environment that the commission uses to set rates. Okay.
Now, let me ask you, I think you mentioned there the concept of essentially the effective date of I believe you prior referencing amendments to the Renewable Energy Act as one marker of evaluating a financial incentive request. Is that correct?
It's a question of when the action was taken and relative to when the rule was, adopted.
Okay. And is it your position, I believe in your testimony, you indicated it is your position that with respect to financial incentive requests, that the commission cannot take into consideration RECs that may have been generated from facilities or procurements that have predated the most recent amendments to the Renewable Energy Act. Would that be a correct characterization of your position?
Yes.
Okay. And are you aware that the Renewable Energy Act prior to the most recent amendments included language that authorized a financial incentive for exceeding the renewable portfolio standard?
Yes.
And just to help me understand why, given that there was incentive language that preceded the most recent amendments, why is it your position, or let me rephrase that. Do you not believe that that language should be taken into consideration when evaluating financial incentive requests made today?
You're talking about the language in a statute that's been subsequently amended?
Yes, but let me ask you this. Are you aware that that language remained the same as between the version of the statute that existed prior to the amendment and now. And
The language-
by language, I mean the language that indicates an incentive request may be made for exceeding the renewable portfolio standard.
So the Renewable Energy Act does have and has had language that suggests that the utility may seek a financial incentive. That part has not changed. Yes, for exceeding the.
Excuse me, I don't want to speak over it. Specifically, it has long included language prior to the most recent amendments that allow for a financial incentive request for exceeding the renewable portfolio standard, correct?
Yes.
Okay.
Yes, the statute, the REA authorized the commission to determine whether a utility was entitled to a financial incentive.
And so given that, is it still your position that the commission cannot consider procurements or acquisitions, cannot consider renewable energy certificates that may have been generated from facilities procured or acquisitions made prior to the most recent amendments? Is that still your position?
Is because the commission rule says that the actions that will be result in a financial incentive must have been taken after the adoption of the rule. So based on that rule language, the way the rule works, the past actions that may have resulted in excess or exceeding the RPS standard would not be eligible for a financial incentive.
Okay, so just to clarify, your position is based on your interpretation of the commission rule.
Yes.
Okay. Now, let me also state in your testimony that as an alternative to seeking a financial incentive and retiring excess RECs, a utility could sell its renewable energy certificates. Is that correct?
Yes.
Are you aware of any limitations the Renewable Energy Act places on a utility's ability to sell renewable energy certificates?
No.
Okay, so have you reviewed section 62-16-5 of the Renewable Energy Act? And particularly paragraph B2.
No, I have not.
Okay, so would it be a surprise to you if I were to represent to you that there is language in the Renewable Energy Act that limits a utility's ability to sell renewable energy certificates generated from a rate-based utility plant?
I'm not that I'm surprised, but I'm not aware of that. I'm not familiar with that limitation.
Okay, so would it be correct to say that when you offered your testimony on suggesting that utilities sell their RECs as an alternative, that was not a consideration, that statute was not something you took into consideration in offering your testimony?
I don't recall if the statute said you couldn't sell it. There may be some limitations, but no, I did not take that into account.
Okay. Now, let me ask you, are you familiar with what SPS is proposing as the basis for its financial incentive in this case, correct? And you're familiar with—
Was that a yes?
Yes. Sorry, Your Honor.
Thank you.
Thank you, Your Honor. And you're familiar with the fact that SPS is proposing that it retire essentially double the amount of RECs that it would otherwise have to in 2023 and 2024, correct? I'm sorry, if you could speak up when you say yes, it's, I think, not being recorded.
That's correct. For the record, sounds like you have a voice actuated system, Mr. Pollock, where it only turns on as soon as you talk. What happens is it clips off the beginning of your voice. That's what I think. I could be wrong, but for some reason I can see your mouth moving, but I can't hear anything. And if Mr. Lee, well, I mean, he could note for the record that he sees your mouth moving, but that's not really appropriate. So we need a clear yes.
Oh, geez, Your Honor. Yeah, yes.
It actually just did it again. All I heard was honor, yes.
Okay.
So if you could, whatever, maybe move the mic closer or turn it off of voice actuation, that might be helpful. Thank you.
Okay.
Thank you, Your Honor. So we were speaking of SPS's financial incentive proposal. Would you agree that if SPS were to move forward with what it proposes and retires excess RECs in 2023 and 2024 in exchange for a financial incentive, that it would have less banked RECs at the end of 2024 than if it did not retire excess RECs? Okay. And that was a yes, correct?
Yes,
Okay.
that's a yes.
Okay. It may be helpful, I believe, if you lean forward to
Okay.
have the microphone capture your voice. And would you agree that if SPS has less banked recs at the end of 2024, that it will have to find some way to replace those recs through the acquisition of renewable generation so that they can generate additional recs?
So that's correct.
Okay. So would you agree that if a utility exceeds the RPS by retiring more recs than required, it is going to have a downstream effect, if you will, on the renewable energy that they have to acquire in later years?
Yes, it'll accelerate the need to acquire RECs to replenish the RECs that were sold and to comply with the growing RPS standard. So there would definitely be an additional cost associated with that.
And would you agree that if the utility needs to accelerate its acquisition of RECs, that's going to require it to produce or generate additional renewable energy that will generate those RECs?
That the REC is associated with renewable energy. So yes, that in order to get more RECs, you'd have to procure more renewable energy, which would entail incurring some additional cost.
Okay, thank you. And I just have one last question for you. So you cite in your testimony the current rulemaking proceedings that relate to the Commission's RPS Rule 572, correct?
Yes.
And I believe in your testimony you referenced some language in the proposed rule changes that are currently being discussed at the Commission, correct?
Correct.
It is, just for clarity, it is not your position that any of those potential rule amendments would be applicable to this matter, correct?
No, it would not. They would not be applicable to this proceeding.
Okay, thank you. Your Honor, that's the entirety of my questions, and I pass the witness.
Thank you, Ms. Kane. You actually covered a few things that I had questions about. But before I ask any questions, let's see if there's any other cross-examination. We don't allow friendly cross-examination, as everyone knows here, so it should truly be cross-examination. Ms. Drake, do you have any questions?
No, thank you.
Mr. Rushoff, any questions?
None for me, thanks.
And of course, not least, but last, Mr. Bogatko.
No, thank you, Mr. Hearing Examiner.
Okay, well, I just had a few things, and I want to state for the record that my examination, in contrast with Ms. Kane's, is not cross-examination. It's examination, but not cross-examination. What I try to do in my limited examination is to clarify things which I think could possibly be clearer. But I'll start, and thank you, Mr. Pollack, for being here. I have just a few questions. I read the Appendix B to your testimony. I was quite impressed. And I'm going to state for the record, it seems to indicate that you have testified in over 250 cases. Is that correct?
Yes, sir. That's just in the past 11 years or so. I've actually been doing this for about 47 years.
Well, how many cases have you testified in during 47 years?
You know, I haven't counted it, but it's you know, maybe close to 1,000 now.
You've done it in 28 states. Is that correct?
Yes.
That's according to your testimony. I suppose my question I'm leading up to is, you're a professional witness, are you not?
I've been to a few rodeos. Yes, sir.
1,000 of them.
Yeah, a few. Yes.
47 years, correct?
Correct.
Thank you, sir. Okay. Like I said, Ms. Kane actually clarified for me a few things. Let me see where I had some other issues that I thought should be clarified. The first time you mention a term, which I'm somewhat familiar with, but I think you need to state for the record what you are referring to. On your testimony, page 4 at line 17, you refer to, quote, the, quote, regulatory compact, unquote. I think I understand what it is, but I'm not sure everyone else does that might possibly read this. I believe counsel here probably knows, you know, but other people can look on our e-docket system online and they can review your testimony. And the word regulatory compact sure does sound like a contract, if you will. Could you please expound on what you meant by regulatory compact?
So the concept of a regulatory compact is that the utility, is allowed to provide service at a reasonably defined area to customers. And in exchange for having that franchise, having that ability to serve customers in a certain defined area, then they are given a reasonable opportunity to earn a reasonable return on the investments that are used to provide that service. So that the compact is in exchange for granting a franchise, the utility gets a reasonable opportunity to earn a reasonable return.
Well, franchise has a certain meaning to lawyers, but what you mean is a monopoly. Is that correct?
A defined service area, which effectively is a monopoly, yes.
And they agree to be regulated by, they don't agree, but they are regulated by the government. Is that correct?
Public Regulatory Commission, regulates the rates, terms, and conditions of service.
So is that what you're referring to when you state regulatory compact?
Yes.
Thank you. Okay. When I see words like should, it really makes my feelers go up, if you will. And you use the word should on page 5. I think Ms. Kane actually referred to it on line 5. Actually, the sentence begins on line 4. You state the commission should demand that the utility meet a much higher standard of proof. Well, standard of proof is, of course, a legal concept. In order to grant relief, typical standard of proof would be beyond a reasonable doubt, typically in a criminal case, by clear and convincing evidence, and by a preponderance. Are you suggesting that that type of standard of proof be different in this type of case?
Yes, I think that in order to go above and beyond the regulatory compact, which provides an opportunity to earn a return, if the utility is asking for a incentive, effectively an additional return, that the commission should have a higher standard of proof, and they should demand that the utility provide evidence that and very compelling evidence that the incentive is deserved. And as I stated in my testimony on page 5, that evidence should be compelling to show that the cost to exceed the standard in this case have resulted in clear benefits.
You'd agree that this is your opinion, correct?
Yes.
You'd agree that it's not legislation, is that correct?
Well, it's not written that way in the legislation, but again, go over my 40 some odd years of, appearing before regulatory commissions. It's kind of part of the overarching standard that commissions use to regulate utilities. So it's not a specific part of any regulatory statute or legislation, but it's part of the regulatory compact. It's part of the understanding that this is what the utilities must do in order to be able to earn a reasonable return on their investments.
In my notes,
and earn incentives on those too.
Are you finished?
Yes, sir. Thank you.
In my notes, I have written, quote, overarching principle. And just now you had overarching understanding. You mean the same thing, correct?
Yes.
Because I wanted to ask you about that. You'd agree that the state government is bound by the law that's created by the legislature, right?
Yes.
you'd agree that we're not bound by a expert's opinion, correct?
You're not bound by it. No, you can weight it as much as you want or not.
Well, that's what I mean. When I see words like should, I wonder, well, I'll just leave it at that and move on. But I wanted to clarify in your testimony, the gravitas of your opinion that what the commission should do as compared to what the legislature mandates that the commission do. Those two concepts are distinctly different, correct?
Yes. Yes,
And
the commission has to follow the legislature. That's absolutely correct.
And your opinion is based on either, quoting you, overarching principle or overarching understanding of the compact, which you defined earlier, correct?
Yes.
Okay. I'll try to move on. I don't want to beat this up. Like I said, I'm not cross-examining you, sir. I'm just trying to make sure your testimony is clear. Sometimes vagueness is used intentionally, and I'm not sure. I'm not saying that's the case here, but in my world, on my end, I prefer things not to be vague, and I like to have a clearer record. I'm looking at page 8. This is a real simple question. You say S&P posts the price of Texas Rex, and I looked at your nice glossary of acronyms. I didn't find S&P. Is that Standard and Poor?
You must actually go. Yeah, it's, the formal name is Standard & Poor's, but the platform that we use is S&P Global IQ, which is the data platform that we use or Capital IQ, which is shown in the footnote. But S&P is Standard & Poor's. Yes.
Well, needless to say, I'm familiar with it, but I'm not sure anyone else that read it might have picked that up immediately, especially laypersons not in the field, frankly, and ratepayers and members of the public here in the state of New Mexico.
I'll be sure to make that in addition to our glossary.
Well, that was something I wanted to get at. And that's a good segue, and I'll move into, since you presented it. Page 13, you're describing J. Pollock, Incorporated, and you refer to the, quote, the J. Pollock team. And when I see that, I'm start thinking, well, is this his testimony or is this the testimony of a team? Is it or is it not your testimony?
This is my testimony. The answer is to describe J. Pollock. So I was describing, the fact that I have other employees that also work on projects and assist clients on energy and regulatory issues. So I'm not a sole practitioner. That's what that means.
Okay, well, I understand that. And I made the distinction that you're describing J. Pollock Incorporated, not J. Pollock. You are J. Pollock, correct?
That's my name, and that's also the name of my company.
And this is also your testimony, not your company's testimony. Is that correct?
That's right. It's my testimony.
For me, it's a distinction.
Right. It's Jeffrey Pollock's testimony, and I work for J. Pollock Incorporated.
Okay. I would not have asked it in that order, but it seemed that you brought it up when you referred to changing testimony in other cases. And I started to think, you're using maybe the same testimony in other cases, or your team is. Let me see if there's anything else I wanted to clarify. Pardon, indulgence, please. I'm familiar with the concept of opportunity cost and foregone cost and foregone benefits. I'm looking at page 8, and you seem to address that. You seem to bring that up, frankly, opportunity cost, when you cite the revenues that SPS will forego in retiring rather than selling excess RECs. Oh, there it is. The word opportunity cost to or an opportunity cost to SPS customers of its proposed RPS incentive. That's a heavy sentence. That's really broad, encompasses a lot of concepts, and seems to indicate that there's been a quantification which supports that statement, an underlying quantification. I'll just ask you an open question, because I'm not cross-examining you, but I'm going to ask you, would you be interested in laying some type of foundation for this very broad conclusion?
Well, the testimony on page 8 addresses the fact that one option that SPS could have, and instead of retiring the RECs, is to sell the RECs. And if they don't need them, they could monetize them, and that could create a value worth between 13.8 and 14.9 million, based upon the price of Texas wind and solar RECs, as discussed in my testimony. And the reason I put that in the testimony is that when we talk about cost benefit analysis, we could look at, well, what's the effect on ratepayers, and does the fact that SPS forgoes the option of selling RECs to the market, does that create a cost to ratepayers? And that's what the testimony demonstrates. So it's effectively, by not taking advantage of the opportunity to sell excess RECs, the company is losing an opportunity to generate between 13.8 and 14.9 million benefits to customers. So that becomes a cost, an opportunity cost of not doing that. It's an opportunity cost associated with retiring rather than selling the excess RECs.
I'm going to ask you about accounting. Who owns the excess RECs?
So the utility, SPS, owns all the RECs because those RECs were generated by their renewable facilities.
And they're looking for an incentive to retire, of course. That's how they've decided to use their excess RECs, correct?
Yes, yeah. The existence of the excess RECs, and persistence of the excess RECs is the reason why SPS feels that they are entitled to an incentive, because those excess RECs, by definition, exceed the RPS standard.
And you believe that not the shareholders, but the ratepayers would acquire between 13.8 and 14.9 millions if SPS would, instead of retiring and acquiring an incentive, would instead sell on the open market the RECs to be used by some other company who would purchase them, or companies, correct?
Right. Yeah, there's a market. They could sell the RECs and monetize the value and provide that value to the customers.
Not to the shareholders.
Right.
All right, I'll move on to something else on page 9. You state that the cost benefit analysis is not as good as it could be, because the SPS used a regional average rather than a SPS specific average. And I've written down, where does it say that? And that's my note to myself. And that's my question. Like, where does it say they should use an SPS specific average rather than a regional average?
Well, I'm not quoting anything that, where it says how to do the cost benefit analysis. I'm simply, saying that if you're doing a cost benefit analysis that applies to SPS customers, it would make more sense doing that to look at the carbon intensity, or the effect on carbon intensity in SPS's service territory, as opposed to a broader SPP South region, which is what they're using for carbon intensity. So I'm just saying it's more accurate. It would have been more accurate to do the cost benefit test, just looking at SPS's service area and not a broader SPP region, which is what they did.
That's your opinion.
Yes, that's my opinion.
Pardon me again, please. Okay, that's all the clarification questions I had. But because I've asked those questions, I'm going to give everyone else an opportunity to ask questions within the scope of mine. Ms. Kane, please. Any questions?
Your Honor, I just have one question to follow up on your discussion about the quantification of the sale of Rex, if I could.
Sure.
Mr. Pollack, you discuss on your testimony on page 8 where you provide a calculation apparently that you made about the 13.8 to 14.9 million valuation if SPS were to sell Rex, correct? Now, is that a yes?
Yes.
And in making that calculation, did you take into consideration whether any of SPS's Rex could not be sold because of restrictions placed on the sale of Rex under the Renewable Energy Act?
It did not factor that into account, no.
Okay, so would it be correct to say you just assumed that every Rex that SPS has could be sold on the open market when you were making that calculation?
The excess Rex, yes.
Okay, thank you. Those are the only questions I have, Your Honor.
Okay, let's go around and see if anyone else has any. Mr. Bogotko.
Not necessary, Mr. Hearing Examiner. Thank you, though.
Ms. Drake.
No questions, thank you.
Mr. Rushop.
No questions.
Okay, well, there will, I can give Mr. McMillan, just to make sure he doesn't have any redirect. Do you have any redirect, Mr. McMillan?
I do, Your Honor.
Briefly, well, go ahead, please.
So, Mr. Pollack, on cross-examination, you were asked
You're breaking up. You're breaking up.
Can you hear me better now?
Not really.
Pretty garbled.
Okay,
Turn off your video.
can you hear me better now?
Yes.
Yes.
Excellent. Okay, so please let me know if I start breaking up again. Apologies. So, Mr. Pollack, on cross-examination, you were asked about whether there are other benefits of renewable procurements other than emissions reductions. Did SPS quantify any economic benefits other than emissions reductions in their application in this proceeding?
No, they did not.
Okay, so you also indicated that it's important to quantify the costs of renewable procurements as well as the benefits. To your knowledge, are there any costs related to proposed renewable procurements that SPS has not quantified in this proceeding?
So there could be other costs, for example, the costs of building out new transmission, to accommodate additional renewable resources, the cost of having to procure additional backup energy to support the supply of renewable resources. So, I mean, putting renewable resources or installing renewable resources is not cost-free, because not only do you have to pay for the cost of the resource itself, but because renewable resources are intermittent, you've also got to provide enough sufficient dispatchable capacity to make sure that the system continues to provide reliable electricity on a 24/7 basis. So those are the additional costs that could potentially be associated with additional renewable procurements.
Is there also a cost associated with accelerating the procurement of new renewable resources?
Yeah, so if SPS retires the excess RECs and as a result has to then accelerate the procurement of additional renewable resources to, again, comply with the growing standard, that itself has a cost. There's a present value cost associated with that, because it's going to involve procuring additional resources at some cost, which we don't know. But that cost, even if it's occurred, in 2 or 3 years down the road still has some present value that should be taken into account in a cost benefit analysis.
Okay. Do you believe it's possible for SPS to fully quantify the costs and benefits of its incentive proposal without proposing a particular future renewable project or procurement?
I think they could do it, but I think the problem is that if the retirement of excess RECs causes the procurement to change, then you have to take that time value of that change, the value of having to accelerate the acquisition of new resources.
Okay, Mr. Pollack, I want to change topics just slightly. So counsel for SPS asked you about limitations on selling RECs that are generated by a utility plant that's in rate base. Do you know, does SPS get all of its RECs from renewable generation resources that are in its rate base?
Well, the RECs that SPS has are RECs that are associated with its resources. But it's also possible that even if SPS doesn't get RECs directly, if, for example, if customers install renewable resources as a result of incentives that they have, that will have some effect on how SPS complies with the RPS standard.
Mr. Pollack, are PPA resources in utility rate base?
Oh, I'm sorry, I misunderstood your question. So yes, SPS does have purchase power agreements for some of the, in fact, for quite a few of the wind and solar resources that are generating the RECs that we're talking about.
Okay, so on page 6 of your direct testimony, you have a table that breaks down SPS's REC acquisitions. Can you confirm which of those resources would be in SPS's rate base?
Yes, so the Hale and Sagamore wind facilities, the first 2 items in table 1 would be in rate base. The rest are essentially acquired through purchase power agreements.
And I note that most of these are labeled PPA. Are you aware of whether the Sun Edison projects are PPAs or not?
I believe they are, but I don't know that for certain. I don't think they're in rate base.
Okay, is it fair to say that that's something that SPS is likely to have addressed in its RPS application?
I would presume so.
So in theory, Mr. Pollack, SPS, assuming that there's a restriction on SPS selling RECs that are generated by rate-based public utility plant, is it possible that SPS could use the RECs generated by the Hale and Sagamore plants to satisfy its RPS obligations and then sell the RECs that are associated with these PPAs?
I don't know if that can happen or not. I'm just not familiar with that portion of the statute.
Okay, fair enough, Mr. Pollack. So one last topic. The on cross-examination, counsel for SPS asked you whether retiring RECs will could lead to downstream effects that will result in SPS acquiring additional renewable energy. Do you know if it's a sure thing that SPS's RPS obligations will continue to grow on an absolute basis over time?
Well, the fact that the RPS standard itself is increasing will tend to push more renewable acquisitions beyond what currently exists today. Although, with SPS's position now, it wouldn't have to do that for a number of years.
Mr. Pollack, are there factors that can potentially offset SPS's RPS obligations? For example, actions taken by customers?
Yes, and I think I'd gone into that before. The fact that to the extent that customers, also acquire renewable resources, that will have a significant impact on the determination of whether SPS it complies. So if for example, if a number of larger customers accounting for maybe 20% of SPS's New Mexico retail sales, if those were self-supplied by renewable energy, that would have a pretty significant effect on the extent to which SPS is able to meet the growing RPS standard.
Thank you, Mr. Pollock. I appreciate the clarifications. Your Honor, that's all the redirect that I have at this time.
Thank you. There being redirect will allow recross within the scope. I'll go straight to Ms. Kane, please.
No further questions, Your Honor.
Thank you, Ms. Drake.
No questions, thank you.
Mr. Bogato,
Nothing further, Mr. Hearing Examiner. Thank you.
and not least, Mr. Rushoff.
Nothing for me. Thank you.
All right, well, that's just wonderful because I think that concludes the cross-examination, concludes my examination and the redirect, and we allowed recross. So counsel, may this witness be released? I'm going to ask Ms. Kane. Yes, she's indicating yes. Does anybody else believe we might need to, this is going to be the end of the case, or recall this gentleman? No, he's released, correct? Excellent. I get nods indicating agreement. Mr. Pollock, I want to thank you for being here. Thank you for your testimony, and you're released for the day. Have a great day, sir.
Thank you, Your Honor, for making this possible. I was not in any shape last week to testify, so I appreciate the disposition.
Thank you, sir.
Thank you for your time.
Thank you. Mr. Lee, could we go off the record just briefly?
Yes, sir.
Thank you. Counselors, off the record, we can only obviously discuss procedural matters, and that's exactly what I want to discuss. I think we discussed last week that there would be no oral closings. Is that correct? Okay.
That's correct, Your Honor.
If I say something wrong, just please say so. So we talked about written closings. They can really get out of hand if there's responses to written closings and then people submit, really long closings. What I think I indicated to you is that I want to know from Ms. Kane how she has proven her case essentially, and from the other parties how they feel that perhaps Ms. Kane has not proven her case, either because of any defect in her case or effective presentation of your case through your witnesses. That's kind of what I'm looking for. I also want to talk about submission of, and perhaps in the alternative, proposed findings of facts or a proposed RD, and see how you guys feel about that. Now, that could be done in the alternative and have essentially the same effect on my end, or it could be incorporated into a closing argument. I'm open for all types of suggestions. Obviously, everyone, my purpose is to give a good due process hearing and have a complete record for which I can do a complete RD, for which the commission can rely upon my RD and the record and issue their final order. So, Ms. Kane, what is your position?
So, Your Honor, I think our contemplation of what might work best, subject to, discussion with the parties, is, because it's the only real issue it appears to be in dispute is the incentive provision. And really the bulk of this case, as you know, is approval of our RPS application, that it may be most beneficial if we, SPS, could offer up essentially a proposed RD on everything but the incentive provision, and maybe even circulate it to the parties and get some sort of agreement on that aspect of it, and then submit briefing and even a potential alternative portion of an RD that would be in dispute as to the incentive provision, so that you could have essentially a package that would maybe be the most useful for purposes of resolving this.
I don't mind saying it. That's exactly what I had hoped for. Exactly. So I completely concur. And if it's not clear to you guys or some member of the public who might be on YouTube, actually, I believe we'd all like this to be resolved sooner rather than later. I'm sure Ms. Kane does, and I do. And for me, that means the end of the year. And the end of the year is less than 2 months away. I think we discussed last time off the record that there are time limits in order to get this before the commission for a final order by the end of the year. And we and I have to hop on it immediately. And I have another case I just concluded, and another case where an RD is due, and another case where there's exceptions taken and I have to appear. So I've got other stuff rolling at the same time. So everything we can do to make this quicker will be helpful, not only to me and the commission, but also to the parties. So Ms. Kane, I completely concur. Let's see if there's any other opinions about that. Mr. Bogatko.
Mr. Hearing Examiner, that was my understanding based on how we concluded the last portion of the first part of this hearing, is that there would be some collaboration on a proposed findings of fact and conclusions of law with a blank left for the areas in dispute. And then we would also do some briefing that would focus on the areas of dispute. SPS obviously would brief how it's met its burden, and the parties in opposition would brief how they think they haven't. And I've already got that deadline in my calendar, and I'm looking forward to getting the transcript for this part so that I can get my brief ready and then collaborate with SPS to the extent necessary on the areas where there is no controversy for your convenience.
Perfect. And we set the deadline as Monday the 14th. Is that correct? Does everybody agree on that? Yeah,
That's correct.
That's perfect. And some briefing, you use that term. I mean, I envision like 5 pages. I'm not putting a limit on you guys, but I don't need 55 pages. You know, cite the record where the testimony is in to support your contention. And there, that's what I need to see. Okay, so let's see make sure all the other parties concur. Ms. Drake?
I have no objection to that approach.
Mr. McMillan?
I agree with Mr. Bogatko's characterization.
And he basically agreed with Ms. Kane, the way I heard it. So, Mr. Rushoff?
Yep, I agree with Mr. Bogatko.
Okay, once again, and he stated, agree with Ms. Kane. Well, I really like the word I heard, which is collaboration. You know, we're all members of the bar, and collaboration can make everything go better and more smoothly. So when Ms. Kane puts together this proposed RD with everything but the incentive issue, which is in dispute, with the proposed incentive part, what I'm hoping is you guys can all agree on it, and then you can agree to disagree on the incentive, and then you can propose your own opinion on interpretation of the evidence in this case and how it supports your client's position, and give me a proposed RD portion just concerning the incentive. Obviously, I'm going to be picking and choosing that part, and you know, perhaps I'll just write my own, but it would help me to write my own, just seeing what you would like to see. That's how it would probably work out. And I will jump on it and hopefully get it done as quickly as possible, and then get it to the OG. Well, I'll file it, then it goes to the OGC, Office of General Counsel, and hopefully they can get it before the commission. One thing I want to mention, there's the matter of exceptions. Since it would be a jointly proposed RD, at least most of it, you could only file exceptions on the part that's in dispute, which is essentially the incentive. If you guys don't waive exceptions, basically that adds at least another 2 weeks. And if there's exceptions filed, it adds much more time. So I'm going to ask you guys right now, it's pretty difficult. I know it's a difficult call, but I want, when we go back on the record, I'm probably going to put on the record that there was an agreement that to waive exceptions for expediency purposes. Now, I can't tell you to agree to that. I'm just asking you if you would agree to waive exceptions. And there's a certain amount of trust involved. I will tell you that if there's a proposed RD and it's jointly proposed by Miss Kane, well, it's jointly would be by everybody by definition, and it's jointly proposed, I'm more or less going to accept it and incorporate it as the RD. That does leave the incentive portion. So there's a matter of trust on whether or not you will be filing exceptions. Keep in mind, yeah, I'm just going to ask right now. So how do you guys feel about waiving exceptions for time purposes? Ms. Kane?
This probably won't come as a surprise to you, Your Honor. I'm not comfortable at this time to waive exceptions as to the incentive provision part. I do think everything else we probably can get there, but not on that aspect, unfortunately.
Okay, well, I understand. And if there was a jointly proposed entire RD and I committed to use it in substance, I understand that you probably could. And we don't have that before us. And frankly, it's like a chain. And if one link is not there, you can't pull the chain. So you're the link. So unfortunately, I can't present that there will be a waiver of exceptions. So there will be a 13-day period post filing of the RD during which exceptions could be filed. And if they're not filed, then things move along quicker. If they are filed, well, then it's only a 13-day. If they are filed, there can be responses. And the case basically goes from uncontested to contested for the commission's purposes, and that can substantially slow things down. I just want you guys to know that. Any questions for me about that procedural concept there? No, I think you guys are all experienced and you've seen it. Ms. Drake.
I have no questions. I just wanted to state on the record that
We're not on the record right now, but you can when we go back on the record. Go ahead.
Like SPS, LES does not waive exceptions with respect to the areas of dispute in this case.
Okay, thank you. Like I said, one link missing, 2 links missing. We still can't pull the chain, and it's actually good that you clarify and put your client's position forward. Do you want to actually put it on the record, or I can just state it for the record?
We have the right to file exceptions unless we expressly waive that right. So I don't think it's necessary. It's in the rules, so that's fine.
Okay.
I just wanted to make it clear since you had asked.
Wonderful. I appreciate it. I really do. Is there anything else we need to discuss off the record? No? Okay, Mr. Lee, can we go back on the record?
Yes, sir.
Thank you. And we are back on the record. We went off for about 10 minutes or so. We discussed just procedural matters. We did not discuss the merits of the case other than as they might relate to procedural matters. The procedural matters we discussed was post evidentiary hearing briefing. The briefing there, we have a due date of the 14th, which is very quick. It's the 14th of November, 2022. And the structure of the briefing will be a jointly proposed or recommended decision on everything which is not in dispute in the application, which essentially is everything except for the incentive request. On the incentive request, there will be briefing on what parts of the record supports the various positions of the various parties concerning their position on the incentive. Also submitted will be a proposed RD from the opposition, not jointly, not necessarily jointly, could be individual to each client, as to what they think I should include in the RD as to their client's position. Obviously, I'm going to look at the record. I'm going to look at what you cite. I'm going to probably end up writing my own RD portion for the incentive, but I do expect you guys to propose one. There was discussion briefly off the record also concerning whether or not we could possibly waive exceptions. And unfortunately, we cannot waive exceptions. So there will be a 13-day waiting period following the filing of the RD, during which exceptions could be filed. We also discussed that the exceptions, because there would be a jointly proposed RD, which I'm likely to incorporate into my RD, the exceptions would likely only concern the disputed portion, which is the incentive issue. Counsel, did I correctly state what we discussed off the record? Ms. Kane is nodding her head indicating yes.
Yes. Your Honor.
And looks like everybody else, Ms. Drake, is that correct?
I'm sorry, sir. I had to unmute myself. Yes.
And Mr. Bagatka, I correctly stated what we discussed off the record, right?
Yes, Mr. Hearing Examiner.
Okay, are there any questions at this point?
No, Your Honor.
I believe we're ready to adjourn this evidentiary hearing, and I'd like to do just that. I want to thank you all for coming back. Mr. Millen, I think you already expressed your gratitude. Your witness certainly did, about us having to come back for this short continuation of this hearing. That being said, I believe we have covered everything. Thank you all for being here. I appreciate it. It's a nice snowy day here in Santa Fe. First one that hit town, it's still snowing out there. So all you New Mexicans, enjoy the snow. And with that, this evidentiary hearing is adjourned. I'm going to close the YouTube, and thank you, Mr. Lee, for being our court reporter. We appreciate your hard work.
Thank you.
Thank you, Rob.
Thank you.
Thank you.
Thank you.
Thank you, Your Honor. Good day.
Thank you, Ms. Kane. Good day to you as well. And again, thank you, Mr. Lee. I think we're off the record. I really appreciate your work.
No problem. I'll try to have the final transcript out by close of business.
Wonderful.